Now, just real quick, this is a new find for me anyway. I don't know if anybody else has seen it, but it's a writ for unrequited innocence in U.S. capital cases, written by Northwestern Journal of Law and Social Policy. It's a firm that takes a look at cases where people could possibly be innocent, and they pass it along. I'm going to skip through this. I'm going to leave it here so you can read it, because some of this is really interesting. But there's something in here that I want to show how misinformation in the case leads people, even lawyers that wrote this. This is written by an actual law and social policy. You'll see what I'm talking about. So I'm going to let it roll down here. I'll stop it to where you're able to read it. And we can go from there. So when you get to this, the defense objected that the video was more prejudicial than probative. But Judge Mark Toll admitted it into evidence, and the prosecution argued that the video gives you a lot of insight into Routier. This is not a picture of a grieving mother. The reason that Toll admitted it into evidence is because if there's documented behavior of a defendant shortly before and shortly after the crime, that behavior is able to be shown as evidence. Now, if it was 3 weeks later or 4 weeks later, if it was a month or so later and she did that, it would still been kind of weird. But the silly string, according to the jurors who sat over the case, Rena Way, she just flat out said, take the silly string out of the equation and you have all the other evidence. Now, they're putting in here that Toll admitted it into evidence as if there was some kind of issue with that. This is behavior shortly before a crime and shortly after a crime. The character of someone that is suspected is indeed under scrutiny at this time. The conviction and death sentence were affirmed on direct appeal, which largely focused not on the sufficiency of the evidence or the fairness of the trial, but problems with the trial record. During pendency of the appeal, however, Texas Monthly published an article, Skip Hollingsworth published an article raising the possibility that Routier's husband, Darren Routier, had something to do with the crime. According to the article, he had twice admitted that shortly before the crime, he had looked for someone to break into the family home as part of an insurance scam, although there was nothing to indicate that anything had been done in furtherance of any such scam. The conviction was affirmed. Now, if Darren Routier would see, they set this whole thing up. This is what happened. I'm going to lay it out, my theory. It started looking around appeals time that they had a solid case against Darlie. They had talked about some evidence, had a couple things tested, and it just looked like they had a solid case. She's coming up on her appeals time. Well, Robbie Key is he used to run this salvage yard, and he was married to this woman, Charlene. But at any rate, Robbie Key had a stolen truck. He got caught in a stolen truck. He blamed it on his ex-wife, said they set him up. You know, he appealed his conviction based on the fact that they used a confidential informant to tell on him, and he wasn't able to face his defendant in court because they were withholding her name. But anyways, he's a thief. And I honestly believe that Robbie Key had something to do with the first Jaguar. Because Darren had 2 Jaguars. Everybody thinks there's only one Jaguar. He had a white one. And that Jaguar did come up missing, right? And I think Robbie Key helped him with that. But there was an incident where Darren was allegedly over at their house talking about this whole break in my house thing. But Darlie was there. And Darlie was so mad about it that she got up and stomped out of the house. Darlie was allegedly there. And when I spoke to Beja told me and the world that Darren and Darlie were trying to, they asked her to help. Beja's the one who told me all about but they asked her to help with this thing, right? They were running out of money. So, I don't know if they're coming around appeal time, and just about the only thing they could do now is make up this thing, right? This whole insurance scam type of deal. I think it's a scam about a scam. Anyways, Robbie G. Key puts this affidavit out. Yeah, Darren came to my house and asked me if I knew this and asked me if I knew that. And he put that out in July. And then a couple months later, in May of that year, Darren comes out with his. So I think that they were just trying to draw enough reasonable doubt for Darlie without implicating anyone else. Because it makes no sense to me that Darren is, these supporters are all over everybody about stuff, right? This person was a drunk. This person couldn't wear glasses. This person, blah, blah, blah. But no one is telling Darren that he needs to give up the names of these multiple people that he was supposed to have asked. He gives no names. Never. Now, let's say it wasn't 6 years after the crime and Darren immediately, in his first statements to the Rowlett Police Department, said, I asked multiple people, blah, 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 blah. They would want their names, and then they would have something to investigate other than Darlie. But since this didn't happen, it wasn't a result of a scam. I think they're putting this fake stuff out there. Just like that whole thing with the letter that Darlie got from her attorney, saying, I can't believe you turned this down, blah, blah, blah. They're trying to say that the state offered her a life sentence if she would just commit, and she just wouldn't do it because she had so much integrity and she didn't do it. But, it's awful funny that letter was mailed to Darlie, but we all see it now. Darlie literally had to send it to someone and say, look what I did. And she was never offered a deal. Anyways, I'm going to let this go. Competence at the crime scene investigation. Admission of inflammatory character evidence. That, I'm not sure what they mean by that, unless it's letters. Allegedly inaccurate trial testimony by expert witnesses for the prosecution. And effectiveness of trial counsel. I don't think she filed ineffective counsel. Expanding on the issue that Texas Monthly had raised, the petition noted that lawyers appointed to represent Routier after her arrest retained forensic experts whose preliminary analysis indicated that the crime scene had not been staged. Before trial, however, Routier's husband and her mother retained new counsel for her, Douglas Mulder, who had defended them for alleged violations of a gag order regarding the upcoming trial. Motorhead told them that the appointed lawyers planned to implicate Darren Parks. They wanted to implicate Darren. Douglas Parks. Douglas Parks also was the attorney who served in Robbie Key's grand theft case in the early 80s, 84. Anyways, Mulder promised not to do that and proceeded to trial without any forensic testimony challenging the state crime scene theory. Well, see, the thing with speedy trial, her trial went maybe 7 months, right? But all of that, the direction and the speed and the length of the trial, is basically in the hands of the defense. By filing motions for continuances for more time to study the case. Mulder did have a vacation coming. He went to Hawaii. But that's all in the defense. And the prosecution can't move him along. You have a right to a speedy trial, and she got one. But the prosecution can't do that. They can't rush to judgment. All that is up to the defense. The petition also challenged the prosecution rendition of the alleged staging of the scene. One piece of physical evidence that had been a bloody sock that the prosecution theorized Routier had planted in the alley 75 yards from the scene. Now, from the home. Now, this is where it starts to get misinformation, and these are scholars. These are lawyers and attorneys and law students that are writing this, right? And you can tell that they did not do the research. She would have had to have planted it there before stabbing herself. That's one way it could have happened, but she wouldn't have had to do that, and she didn't. Since it contained the blood of both boys, but her blood was not in it or in the vicinity. Now, in this, it also doesn't say anything about her DNA being on the inside of the toe. And see, this is what's going out to the public. She made a call to 911 that lasted 5 minutes and 44 seconds, presumably after planting the sock. That's not true. Paramedics arrived a little more than a minute after the call ended, just as Damon Routier took his last breath. That would be when the timeline started, according to testimony, which a state pathologist testified could have been no more than 9 minutes after he had been stabbed, and that's not what's said. Parchment said you cannot tell, and the time would actually start when he fell and collapsed. That's what she said. So they put this stuff out to the public without, these are scholars who didn't look at the testimony. They're putting things wrong. No state pathologist. Well, at least they're not saying medical examiners like Tara did. Thus, after stabbing the boys, Routier would have had to plant the sock, stage the scene. Nope. No timeline. And see, this is why she's going to stay right where she's at. All someone has to do is look at what the state pathologist actually said. And then you can just erase all of this. When the appellate process emerges from the abeyance, there is a chance, based on the issues raised in the 2005 petition, that the conviction will be reversed and the case remanded for a new trial, leading to the dropping of the charges or an acquittal. But as of May 1, 2019, Routier, 49, remained one of 6 women under death row sentences in Texas. See, they're basing it on this, though. They're basing it on something that isn't right. So when the courts actually do go back and look at that, and if they bring that the medical examiner that was on the stand back then, who is still practicing, and he would just say the same thing again. The defense was the one who said, oh, so it could be 9 minutes or more. He did limit it to minutes. That's about the closest you get to a 9-minute timeline. He said minutes. Now, from 1 to 59, you have minutes. After that, you got hours. But basically, when he said, so it could be up to 9 minutes, I think it was Mosty, and they said, you can't tell. He said, you can't tell. But I thought this was interesting that this is being put out by a law school. And it's misinformation, simple misinformation. The reasons that they say that Darlie is innocent have nothing to do that happened in the trial. So I thought that would be an interesting read to discuss.